All right, y'all, welcome back to the show. It's Anti-War Radio. We're at chaosradioaustin.org and at lrn.fm. Archives at antiwar.com/radio. And our first guest on the show today is Pardiss Kebriaei from the Center for Constitutional Rights. Welcome to the show.
Thank you very much.
Very happy to have you here. CCR condemns President Obama's embrace of military commission system, reads the press release. What embrace, and why do you condemn it?
It's an embrace of a system that President Obama himself criticized under the former administration, and we're criticizing it because the system that appears to be about to come back in force is not, will not ensure fair justice for the people who will be charged. And it just demonstrates yet another failure of leadership by the president on issues relating to Guantanamo.
It's confusing to me, and I guess I'm not in the mind of Rahm Emanuel or any of these people who helped the guy make his decisions up there, but it seems like good politics would have been to do what he said he was going to do. And It seems really bad politics because he looks like a terrible pro-terrorist traitor to all the right-wingers anyway for even saying he ever wanted to close the thing. But now all he's done is anger all the libertarians and all the liberals who thought, well, geez, at least he's going to close down Guantanamo Bay.
Right. I mean, I think given the string of broken promises and reversals of his positions, it does seem like politics is dictating, his reasoning rather than principles and the rule of law. And that's clear with respect to closing Guantanamo, which he promised to do on his second day in office to great fanfare. It's clear that the prison's not going anywhere anytime soon.
Right. It was 2 years ago today, right?
Right. Well, tomorrow, I think. Yeah, the 22nd.
No, today's the 21st.
Right. Yeah, you're right. Yep. So Guantanamo, the closure of Guantanamo is one example, and the way that detainees will be charged and tried is yet another. He's critical of these commissions under President Bush, campaigned on a promise, and as president promised to indicated that he was going to use civilian courts to charge detainees. Didn't believe that military commissions would provide swift or meaningful justice, and yet he's now preparing to bring them back.
Well, and that's really my puzzle about Guantanamo is, from his point of view, why not go ahead and follow through? Because what difference does it make? They already announced from the very beginning, even during the dueling speeches with Dick Cheney, where he stood right there in front of the Constitution. He said, and we'll set up the system so that no matter what, we'll hold these people forever. If they're ever acquitted, we'll still call them enemies and hold them in prison. So don't worry about anybody being let go by a jury or anything like that. And so why not just do the thing in Illinois? If they're bringing Guantanamo to Illinois, literally the entire package, then, it just seems bad PR to keep it in communist Cuba.
Right.
I mean, they're making Fidel Castro look like he's got a fair system over there.
Right. Well, I mean, there's really, Guantanamo is not a complicated issue, and it's become complicated because of politics. But there are 173 people left there. Dozens of them have been cleared to leave the prison by President Obama's own task force. And when we say they've been cleared to leave by the government, that means that people with a stake in the matter from every agency in the government, the FBI, intelligence agencies, Department of Defense, Department of Justice, Department of State, have all had a say in the matter and have looked at the cases of everyone there and determined who can leave. And there are dozens of men who have been determined able to leave. And they should not continue to spend another day in Guantanamo. They're entering their 10th year of detention. And as for the rest of them, they should be charged if there's credible evidence against them, or released. And the civilian courts, federal courts, have been proven to be adequate tribunals for the trials of people suspected of terrorism. There have been hundreds of convictions, if that's what the government's after, in civilian courts. So there's no reason to fear that a system that's been tested over and over again in hundreds of cases couldn't deliver justice for the men charged at Guantanamo.
Seems like the way we are now was all decided on the afternoon of September 11th when Cheney and Addington said, this is a war. And it doesn't matter that terrorism is already a crime on the books. We're going to use the plenary inherent power of the president as commander-in-chief to do whatever he wants rather than impanel any grand juries anywhere. Right.
And I think, that starting point is really worth talking about and taking a look at. All of this has come into being, the past decade of detentions and torture and use of military commissions has all been because the president and the executive branch have said, we can do this because we are in a time of war. But what that means and the scope of the war and who can be targeted are all questions, but that the president and the executive branch have said we have the power to determine. A really frightening thing we're seeing now is, even if you accept that 9/11 triggered a war between the United States and al-Qaeda that existed in Afghanistan, and if you accept that there was a war between the United States and Iraq, those are defined boundaries for those wars, and the laws of war may apply there, but saying that they sort of reach globally, which means that the executive branch could designate anyone an enemy and do anything to them, whether detain or kill or torture and interrogate, is absolutely illegal. And yet the government's been able to continue claiming that kind of authority, and we're now seeing it in the context not just of detentions and military commissions, but killing authority. The government is claiming that it can target and kill even U.S. citizens anywhere in the world, essentially. And we have a case, DCR has a case that we filed on behalf of a U.S. citizen in Yemen, whom the president has designated a terrorist, an enemy of the state, and has said that they can target and kill him based on their own determinations without having a court involved at all in terms of reviewing the allegations and reviewing the scope of the executive branch's authority. So we're really, actually under Obama, seeing an expansion of the kind of power that President Bush asserted and that was condemned in the United States and internationally.
Well, it's funny because, George Bush had David Addington and John Yoo and all these people to say, well, you're the commander-in-chief, and that's it. Those are the only words in the Constitution. You can do anything, including put troops on the street. And we've seen in the memos they have the right to violate the First and Fourth Amendment and anything else they want. The entire world is a battlefield, et cetera. But Obama, I guess this is the only real so-called improvement, or maybe it's counterproductive, has said, no, we don't believe in any of that. Really, Bush kind of repudiated a lot of that in the second term, too. No, it's just the authorization to use military force passed by the Congress that gives him all the exact same powers, the power to decide what torture is and whether to implement it or not, the power to detain people forever and ever, the power to apparently, pick countries to have wars in without even telling Congress about it, like Yemen and Somalia.
Right. Right. I mean, the President Obama is using the same authorization and asserting the same commander-in-chief powers as well, not just congressional authorization that was from, now a decade ago after 9/11 as the basis for what he's doing now outside of Afghanistan, but claiming, inherent presidential powers to be able to conduct this so-called war on terrorism in any way that he wants.
Oh, so really I had that wrong, that he had sort of followed Bush in backing down from that whole Addingtonian argument that you're the president, you can do anything you want. He is claiming that mantle.
Well, I think it depends on the issue you're talking about. I mean, right. With respect to targeted killings, for example,
right.
in court, the basis they seem to be asserting there is both the AUMF.
Well, in fact, I wanted to ask you specifically about what your latest turn in front of the judges came to when we get back. Everybody, it's Pardiss Kebriaei from the Center for Constitutional Rights on Anti-War Radio. Hang tight. All right, y'all, welcome back to the show. It's Anti-War Radio. I'm Scott Horton, and I'm talking with Pardiss Kebriaei from the Center for Constitutional Rights, and I'll encourage you to go back and check my last interview of her is from August 3rd of 2010. Last August, and it was about the ACLU CCR lawsuit attempting to enjoin Barack Obama from murdering American-born, American citizen accused, in the media at least, terrorist Anwar al-Awlaki. And now, last I heard, the federal court told you guys, yeah, well, what are you going to do? This is up to the president, not to the court, to stop something like this.
Right. Our case was, we claimed that the Constitution, it's important to clarify what we were asking. We were basically just saying that whoever this person is, whatever the government has said about him and alleged for him to have done, there should be some law, some legal framework that governs what the president can do. And we said the Constitution is what, the U.S. Constitution is what should govern the actions of the U.S. government vis-a-vis a U.S. citizen in Yemen, which is where the government said they want to kill this person.
I don't know. That's a pretty far-fetched premise to base your suit on.
It is a pretty radical proposition. But,
yeah.
We said, we just asked the court to determine the constitutional standard that would govern any killing of al-Awlaki in Yemen, and to keep the government from killing him outside of that framework. And basically, what the court said, in addition to saying that our client, who's actually the father of Anwar al-Awlaki, is not the appropriate person to bring the case. So the judge dismissed on standing grounds, but he also said that these questions of what the president can do when it relates to issues of sensitive military affairs or foreign policy or national security are just not for the court to decide. These are matters that should be left entirely to the executive branch, and that the court cannot play any role at all in reviewing executive claims of authority. So, he dismissed the case without reaching any of the merits of what we were saying, but basically just throwing up his hands, basically, and saying, I don't have a role here.
Well, and it sounds like he was just kind of hiding behind the standing issue there, right?
Well, I don't know. We could speculate about why he reached, the second question of these sort of political questions, or what they're called, political questions he couldn't reach, because presumably, we might have been able to fix the standing problem. So it might have been that he wanted to make sure the case didn't go forward. But in any case, there are those two grounds for the dismissal, and the second.
So what's next in the case then?
Well, we're discussing what to do next, and we haven't made decisions yet. We're consulting with our client.
I'm afraid that Roberts, Alito, and Scalia, and Thomas, and them are going to get their hands on this thing, and then once they decide wrong, that's it, right?
Well, we'll see. I think the Supreme Court actually, if you look at the most parallel cases to what we're talking about here, which are the Guantanamo cases, for example, the detention challenges to President Bush's claimed authority, from the past decade. The government made many of these same arguments about, these questions about military affairs and foreign affairs and national security are the business exclusively of the executive branch, and the courts should not interfere. That is an argument they made repeatedly in those cases, and it was an argument that was repeatedly rejected, actually, at the Supreme Court. So, I think there's some good precedent for us in those cases.
Although, really, you look at, I guess it was the Rasul case that said, nope, you can't do the military commissions this way because you're just the president. You have to have Congress do it. And so here we are still.
Right.
Didn't really change anything, those big cases. Yeah,
that was the Hamdan case. But you know what, I think all those cases, the detention cases, the military commissions cases, the string of cases all demonstrate is that there is a separation of powers in our system of government, and the courts have a role to play, the executive branch has a role to play, and that the separation of powers is ensured to prevent abuse and to prevent the consolidation of power in any one branch. And that's why, having judicial review is so critical. It's really to prevent abuse, even if what people think the president's doing now with respect to one person is the most reasonable and rational thing in the world. There's a legal precedent that's set. And the whole reason behind having an independent branch of government look at things like this is to prevent abuse in the future when that kind of power is in someone else's hands. And you can
Right,
imagine
and we're supposed to count on the avarice and the self-interest of the judges, as James Madison wrote it in Federalist Number 10. Ambition must be made to check ambition. But
Right.
it sounds like the judge that you last had this case before has no ambition whatsoever to smack the government down, when that ought to be what makes him feel good, is saying, no, government, you can't do this to someone. And instead he says, oh, yeah, sure you can, when
Right.
we all know that that's preposterous, that Obama has the power to order Americans put to death by himself like that, no matter where they are in the world. And this judge wants to pretend that he doesn't know for a fact that that's absolutely criminal and wrong?
Well, I think, one of the things that sort of colors this case there is the particular individual we're talking about on both sides, that we're talking about President Obama. We're not talking about President Bush anymore, and we're talking about someone the government, President Obama, has said is a dangerous person. But if you strip away those two people, the reasonableness, the supposed reasonableness of President Obama and the particular allegations against this person, we're just talking about the executive branch on its own being able to say who is an enemy of the state and to be able to authorize that person's killing without any kind of review. So if you substitute, an innocent U.S. citizen or an innocent person in the place of this particular person, it's the same kind of power that's being asserted, and it's a really terrifying proposition that the government could be able to do that.
Sure, and even in this case, all we know about this guy al-Awlaki is that our government says he's a really bad guy.
Right.
I mean, I haven't even seen any decent independent journalism saying, oh, no, he really is. I mean...
Right. And I think, the experience of the past decade of detentions at Guantanamo is a really good example of how the government made really, inflammatory allegations and really serious allegations against hundreds of people. I mean, what they're saying now about this person really sounds a lot to me like what I'd heard them say about many of the men that we represented at Guantanamo. Whose files I've seen. When you actually take a look at the evidence and you actually have an independent court review those things, what's happened is that the majority of cases that have actually gone forward in federal court, judges have found detentions to be unlawful, and the government itself, once it's carefully reviewed cases, President Obama's government administration has found that many men can be released. So clearly there have been mistakes made before with respect to hundreds of people, and there's no reason to trust what the government is saying on its own now, than there was before. So,
well, now, do they treat in Afghanistan, or do they at least claim to treat the prisoners there as POWs under the laws of war? They have a special, globally designated terrorist identity for all them too.
The situation in Afghanistan and for example, at Bagram is less clear, and I think actually, the situation there is closer to what Guantanamo used to be, where those men, they don't have access to attorneys. It's not exactly clear what the factual basis or what the legal basis is for the government's detention of them, but presumably it is that, the same thing they've been saying in Guantanamo, which is that we're in this war, and the government should be able to hold people, enemies, for the duration of that war, which, as we know, could go on indefinitely.
Right. Well, and we know too that they're taking people from all over the world and sending them to Bagram because they can't put them in Guantanamo. Right.
Right. But this administration, and certainly the last one, was really selective about what parts of the laws of war they were going to pick and choose from. So when it came to being able to detain people indefinitely for the duration of a war, they said, you can do this under the laws of war. But when it came to things like humane treatment and certain standards for review and things like that are also required by the laws of war, they said, well, those don't apply. So it's been really selective enforcement, even within the war context. Mm-hmm. But, that's Afghanistan. What's clear about Guantanamo is that, there are certain rights people have there, and certainly when we're talking about targeted killings, for example, in Yemen, that's thousands of miles away from any war that's going on in Afghanistan. So,
all right, well, on this first anniversary of Obama's breaking of his promise to close Guantanamo Bay in 1 year, what do you think is the future of Guantanamo Bay? They can't just keep a gulag down there in Cuba forever, can they?
Well, I think people who are outraged by Guantanamo and think it should be closed should be clear that, it doesn't seem to be going anywhere anytime soon, and that there are 173 people there most of whom are probably innocent of any of the allegations the government has made against them, and yet continue to be detained indefinitely without charge. So Guantanamo is alive and well, and people need to know that and to learn the facts and to learn the stories of the people who are being detained so that we can counter these sort of generalized stereotypes and myths that people opposed to closing Guantanamo continue to perpetuate about everyone down there being dangerous and being a recidivism risk. We have represented people at Guantanamo since 2002 and have gone down there and personally met with people who are still there and many who've been released. And the men down there, I can tell you, most of them just want to be released and want nothing more to do with the United States or Guantanamo. They just want to move forward. They want their freedom. And the people who've been released, who we're still in contact with, are slowly rebuilding their lives without incident. So, it's just, we really need to try to counter just these broad brush statements that President Obama, another disappointment is that he really has not educated the public at all about who he knows is down at Guantanamo. They are not all dangerous men. They are not terrorists. Many of them are innocent. And he really has failed in educating the public. So we need to. Those of us who want Guantanamo to close, who think it's a stain on the reputation of the United States, that it is immoral and illegal, need to take up that work on our own.
Right on. Well, listen, I really appreciate the standard that you guys set there at the Center for Constitutional Rights and all your activism and, of course, your time on the show today. Everyone, that's Pardiss Kebriaei from the Center for Constitutional Rights. Thanks again.
Thanks. Bye-bye.